My name is Catherine Fryer. I'm an employment lawyer who assists ACC in personnel matters, including training. Today's program is on the college's complaint and grievance procedures. As supervisors, you play a special role in these matters and should be well aware of the college's rules, especially in connection with employee complaints, for which you're usually the first person to address the matter. You have a responsibility to know what is required of you. For details regarding both the complaint and the grievance dispute resolution processes, you should refer to Administrative Rule number 6.08.005 and the guidelines and procedures of the same number, and the Employee Handbook under General Job-Related Information, the section on resolution of an employee complaint or grievance. These procedures are available for all staffing table employees and members of the adjunct faculty. ACC's Employee Handbook identifies two primary types of employee dispute resolution processes: complaints and grievances. They cover separate topics and are subject to separate procedures. A complaint is defined as a written request for the resolution of an issue that relates to an employee's work conditions or relationships, including but not limited to relationships with colleagues and or supervisors, communication and interpretations of administrative rules and policies, job duties, responsibilities, assignments, performance, evaluation and compensation, and work conditions, safety, and environmental concerns. A grievance is defined as a written request for the resolution of an issue related to one's employment status within the college, such as probation, suspension, or termination, academic freedom, or an alleged violation of state or federal law. As you can tell by these definitions, complaints are rather general in nature and are concerned with the routine terms and conditions of employment. Of course, employees are very concerned about the subject matter of complaints, but grievances, by their nature, are more serious. Dispute resolution may be formal or informal. ACC encourages its employees to make every effort to resolve their problems informally, if at all possible. They are asked to take the time to talk to the supervisor informally about concerns, to see if there's a way to work things out without pursuing a formal complaint or grievance. The employee and the supervisor are expected to engage in open and professional discussion to resolve the concern. Employees frequently say that they cannot get their supervisors to meet with them informally about complaints. You should certainly make every effort to be available for informal discussion. Failure to attempt an informal resolution will usually influence the employee to begin a formal complaint or grievance procedure. Sometimes the problem an employee is having directly involves his or her own supervisor. If the employee does not feel comfortable trying to work it out with their supervisor, the employee can talk to the supervisor's supervisor or just go to the Human Resources Department. Despite your best efforts, if you and the employee are unable to work things out on an informal basis, the employee may make a formal complaint or grievance, and these are some general considerations that apply. With respect to all work-related concerns other than termination of employment, an employee must file a complaint or grievance within 20 working days from the date of the situation that created the concern, or within 20 working days from the date of awareness of the concern if the employee was unaware of it at the time it occurred. In a termination situation, on the other hand, a grievance must be filed within 10 working days of the date of termination. The filing of either a complaint or a grievance does not have the effect of delaying or stopping the decision or action that's being complained about. Keep in mind that the deadlines established by the rules refer to working days. Working days are defined as only Monday, Tuesday, Wednesday, Thursday, and Friday. The term working days does not include Saturday or Sunday, even if an employee works on one of those days. Working days do not include holidays or any time that the college is closed, like at spring break, for instance. All time limits expire at 5 p.m. on the working day of the deadline. Prior to the expiration of any time limit established by the administrative rule or guidance, a party to a complaint or grievance may request an extension of that time limit. The request must be made to the Vice President of Human Resources, and it will be granted if it is justified. A written complaint or grievance should be filed in order to commence the formal dispute resolution process. Employees may obtain forms from the Human Resources Office or from the campus manager's office. Formal written complaints are filed with the employee's immediate supervisor or with the next level supervisor if the immediate supervisor is the reason for the complaint. And the appropriate supervisor will forward a copy of the complaint to Human Resources. So whether you receive the complaint or your supervisor receives a complaint, a copy of the complaint needs to go to HR. Formal written grievances must be filed with the Vice President of Human Resources. So let's talk about the complaint procedure first. There are important deadlines that you should be aware of if you are the supervisor handling the complaint at the first level. A complaint may be filed by an individual or by a group of individuals if the group has a common problem that they seek to resolve. A complaint is filed with the employee's immediate supervisor, or if the immediate supervisor is the source of concern, with their supervisor. Once a formal written complaint is filed, the supervisor has 10 working days to meet with the employee to discuss the complaint. The employee may already have made an effort to resolve matters with the supervisor on an informal basis. Nevertheless, this step should not be skipped. Make sure that you meet with the employee and elicit all of the information that you can about the complaint. To the best of your ability, ascertain all the facts that the employee says supports the employee's position. Obtain copies of documents or other physical evidence relevant to the decision. Request dates of occurrences. Identify witnesses. And ask the complainant how he or she would like for the complaint to be resolved. If the employee is relying on ACC policy or any other physical evidence, be sure to obtain the documents and review them. After this meeting, the supervisor or other appropriate person that's handling the complaint has 10 working days within which to respond to the complainant in writing. The response may totally resolve the complaint to the employee's satisfaction, or the opposite may be true, or the resolution may be a compromise that the employee can live with. Within 10 working days of receiving the supervisor's response, the employee must notify the supervisor of whether the complaint has now been resolved. If it has been, that's the end of the complaint procedure. If it has not been, the employee may appeal. The employee has an additional 5 working days to submit a written complaint appeal. The appeal has to contain the original written complaint along with the supervisor's response, and it has to go to the next level supervisor. A copy of all of that goes to the original supervisor who considered the complaint. Now we're at level 2 of the complaint procedure. The next level supervisor has 10 working days after receipt of the complaint and the supervisor response to meet with the employee to discuss the complaint. The next level supervisor then has 10 working days from the date of the meeting with the complainant to respond to the employee in writing with a copy going to the lower level supervisors who have considered the complaint. Once again, the employee will have 10 working days to decide whether the complaint has been satisfactorily resolved. If it hasn't, An appeal must be filed with the next level supervisor within 5 working days. This procedure is repeated all the way up the chain of command and ends at the level of supervisor who reports directly to the president, CEO. The only time the president, CEO, is the final level of review is for complaints by employees who report directly to the president, CEO. At the final level of review, the reviewer has 10 working days to interview the complainant, conduct an investigation review, determine the facts, render a final decision, and communicate that decision in writing to all parties and to the Vice President of Human Resources. This reviewer's decision is the final resolution of the complaint. The Vice President of Human Resources has the responsibility to ensure that the final decision is implemented and documented in the employee's master personnel file. This concludes the discussion of the complaint procedures, and we will now turn to the handling of grievances. A written statement of grievance form must be completed and submitted to the Vice President of Human Resources. Within 5 working days of receipt, the Vice President of Human Resources must forward the grievance form to the Vice President or Associate Vice President who has supervisory responsibility for the grievant, or if none exist, to the appropriate Executive Vice President or other supervisor who reports directly to the President. If the grievant reports directly to the President, the form goes to the President. The administrator addressing the grievance has 10 working days to meet with the employee to discuss the grievance. If you are the Vice President or Associate Vice President who has supervisory responsibility for the grievant, it is important for you to get all of the facts and documents that support the employee's position, dates of incidents, identity of witnesses, and the desired outcome. Again, if an ACC policy or other physical evidence is involved, be sure to secure the documentation. If the employee doesn't have it present at the meeting, you can ask them to submit it to you after the meeting. If the employee believes a state or federal law has been violated, find out what law is in question. After the meeting, the administrator has 10 working days to gather data, conduct an investigation, determine the facts, render a decision, and submit the decision in writing to the Vice President of Human Resources. That is a lot to do in 10 working days. After reviewing the decision, the Vice President of Human Resources has 5 working days to notify the employee in writing of the decision. Upon receipt of the decision, the employee has 10 working days to notify the Vice President of Human Resources in writing whether the decision is accepted or not. If it is accepted, the Vice President of Human Resources will provide written notice to all relevant parties of the decision within 5 working days. A copy of this final decision will be placed in the employee's master personnel file. If the decision is not accepted by the employee, the Vice President of Human Resources has 10 working days from the day she receives written notice from the grievant that the initial decision is not accepted to notify all relevant parties of the decision not to accept the initial decision. If the decision is not accepted by the employee and the administrator addressing the grievance reports to the Executive Vice President, then the appeal steps repeat at the next level with the appropriate Executive Vice President. The Executive Vice President is the final individual who will consider the grievance unless the grievance is filed by someone who reports directly to the President of the college. In that case, the President is the final decision maker. If all levels of review have been exhausted and there is not a decision acceptable to the employee, at this point, the employee may request that a grievance review committee be established. The request must be made on a Request for Grievance Review Committee form and submitted to the Vice President of Human Resources within 10 working days of receipt of the last decision. This 10 working day period coincides with the 10 working days that the grievant has to consider whether or not to accept the decision and provide written notice to the Vice President of Human Resources. If an employee does not accept the decision but does not timely request the formation of the Grievance Review Committee, the last decision is final. It will be distributed to all parties and placed in the employee's master personnel file. If a Grievance Review Committee is requested, a 4-member committee will be formed in the following manner. The grievant submits a list of 5 employees to the Vice President of Human Resources. 2 employees from this list are selected by the relevant administrator, usually the president of the college. The president of the college submits a list of 5 administrative employees to the Vice President of Human Resources. The grievant selects 2 administrative employees from that list. The committee selects a chair to preside at meetings and a secretary to take notes and assemble documents. The chair and the secretary are both voting members of the committee. Before materials relevant to the grievance are distributed to the committee, and before the committee begins its investigation, all members must complete Grievance Review Committee training. Then the Vice President of Human Resources will deliver all grievance appeal documentation to the selected Grievance Review Committee chair. A Grievance Review Committee is a very important part of the grievance process. The persons selected to serve on the committee are charged with being impartial finders of fact. Even though committee members may be selected by a particular side, if you will, be it by the grievant or by the college, no member represents a particular interest in the committee's deliberations. The interest to be served is to be fair to both sides in the resolution of the matter. Also, committee members may personally know the grievant or may be aware of some of the facts pertaining to the grievance. Nevertheless, all of that must be put aside. Deliberations and the final recommendation must be based solely on the facts discovered by the committee in the course of its investigation. The committee must conduct a thorough investigation, gather relevant documents, deliberate, and prepare a report and recommendation to the President. The committee itself does not resolve the complaint, but provides the President with the facts and makes a recommendation based upon the committee's findings. There are timelines in this process, just as in each step of the grievance procedure. The committee must meet with the grievant within 10 working days from receipt of the grievance appeal documentation. The committee shall review the materials, conduct an investigation, determine the facts, and submit its written recommendation to the President within 20 working days from the date of the meeting with the grievant. If the committee cannot develop a recommendation supported by a majority of the members, it will provide a written report to the President explaining the views held within the committee and their purported justifications. The President must review the recommendation or report of the committee and render a final decision within 10 working days. This final decision is sent to the Vice President of Human Resources for distribution to the employee and the employee's supervisors at each level. The Office of Human Resources will ensure that the final decision is implemented and that documents related to the grievance are recorded appropriately, including preserving a record of the final disposition of the matter in the employee's master personnel file. Let's look at some general issues that pertain to both complaints and grievances. First of all, you should know that an employee may have a representative present at all stages of the complaint or grievance process. This representative may be a coworker or another employee of the college, an attorney, a friend, a family member, or a member of an employee organization. It may not be a college supervisor or administrator unless the complainant or grievant is a supervisor or administrator of the college and wants another supervisor or administrator to be the representative. In that case, a request for approval must be filed with the Vice President of Human Resources. If the representative is a college employee, the college grants paid administrative leave to attend scheduled meetings, but not to prepare for the meeting. If a complainant or grievant intends to have a representative present at a meeting, the employee must notify the Vice President of Human Resources in advance. While the representative may be present, the person considering the complaint or grievance will want to hear directly from the employee, so the representative's role is somewhat limited. The purpose of the interview, whether it's in connection with a complaint or a grievance, is to gather facts. Those facts must be based on first-hand knowledge. The person being interviewed will be the person with first-hand knowledge and not the representative. So a representative should not necessarily be completely silent, but primarily the interviewer is going to want to hear from the ACC employee. The next consideration is that mediation is a tool that is available at all levels of dispute resolution. In the interest of resolving disputes promptly, use of mediation is often effective. Mediation is a process in which a trained third party meets with the parties to assist them in reaching an agreement. Mediation cannot be compelled by one party to the dispute. All parties must agree to submit the dispute to mediation. Whenever mediation is used, it temporarily halts other dispute resolution processes and timelines from the date that mediation is requested in Human Resources through the date that the mediator reports that the mediation process is over, whether successfully or unsuccessfully. In the event that mediation is not successful, the process picks up where it left off and timelines begin to run again. When an employee makes a complaint or a grievance, the employee cannot expect the matter to be treated with absolute confidentiality as a rule. Often, in order for a decision to be made, there must be an investigation conducted that will require witness interviews. Investigations are conducted in order to fairly evaluate the complaint, to enable the decision maker to formulate a response that addresses the facts as the decision maker determines them to be, and to ensure that appropriate action is taken by the college. The scope of the investigation will vary depending on the nature of the complaint. If a party to the complaint or grievance is having trouble meeting a deadline, the party may request an extension, which will be granted for good cause. If a deadline is missed without an extension having been granted, however, the complaint or grievance is considered resolved in accordance with the last college response on the matter. If the person investigating the complaint or grievance fails to meet a deadline, the employee may skip to the next level of the complaint or grievance process. Retaliation against an employee who uses complaint or grievance procedures or against an employee who cooperates with an investigation of a complaint or grievance is prohibited. This protection attaches at the informal resolution stage and continues even after the complaint or grievance has been finally resolved. Let's talk a little bit about conducting investigations. I want to provide some guidance on conducting investigations if you're charged with investigating a complaint or grievance and you feel that an investigation is warranted. These investigation guidelines apply whether you're investigating a complaint or a grievance. First of all, do not prejudge the complaint or the complainant. If the complaint is about another employee, you can't think to yourself, "Oh, I know John Doe. He's a hard worker and a stand-up guy. He'd never do anything like that. The complainant must be lying." You never know. John Doe might have done exactly what the complainant said he did. We don't know everything. You must keep an open mind and take all complaints seriously. Listen to the complainant and all witnesses. Try to learn everything you can about this complaint. You do this by really listening to the complainant and the witnesses. If you fail to do this, you may be missing out on some important information and putting the college at risk. Don't tune out the complainant because he or she is a constant complainer. As the joke goes, just because you're paranoid doesn't mean there's not someone out to get you. Even constant complainers can have legitimate complaints, and it's your job to determine whether this complaint is legitimate. Treat the complainant and all witnesses with respect. Don't use a tone of voice or body language that conveys anger, resentment, contempt, skepticism, irritation, or the like. Be patient, be professional. Be completely neutral throughout your investigation. Compassion is a good quality for an employer, but expressing sympathy at any stage of an investigation can lead a complainant to feel that the supervisor is agreeing with their allegations. This can lead to bad feelings if the supervisor actually reaches the opposite conclusion. Maintaining a neutral attitude is really important from the initial meeting to the conclusion of the investigation. Sometimes an employee will ask if they may tape your conversation. You really can't prevent an employee from taping, so my recommendation is that you go ahead and give your permission. If the situation arises and you don't have a recording device of your own, you may want to pause the interview long enough for you to get one. Recordings can be edited, and you want to make sure that you can provide a true and complete recording of the conversation if you know the other side is taping it. Rather than risk delaying the interview, you may want to just have the practice of having a recorder with you so that you're able to use it if the question arises. Whether or not you're aware that a conversation is being taped, you should always conduct yourself professionally and never say anything that you would not want the world to hear. Immediately following a formal meeting with the complainant, make coherent, well-organized notes. Do not delay doing this because you could forget critical facts even if you were taking some notes during the meeting. These notes should be completely unbiased and should contain no conclusions or characterizations of the fact. For example, your notes should not indicate agreement or disagreement with any of the complainant's statements. You should say simply things like, the complainant told me X, Y, and Z. Don't state what he or she told you as fact, but say that these were the allegations that were made. Keep in mind that these notes may be disclosed under the Public Information Act or in response to discovery requests in a later lawsuit. Be sure that you always date and sign your notes, and when you date it, put the full date, the month, the day, and the year. Write down what is said and do not editorialize. How can you best conduct a thorough investigation? The first step in the process, of course, is your initial meeting with the complainant or grievant. Get as much information about the complaint as possible. You need to get answers to the typical questions: who, what, where, when, why, and how. Go over each part of the complaint separately and press the employee to give you all the facts that he or she claims supports the complaint. Press the employee to give you as much detail as possible about the facts underlying the complaint. Ask open-ended questions, not leading questions. A leading question is one that suggests the answer or can just be answered yes or no. Identify witnesses. Remember that the goal is to conduct a thorough investigation as discreetly as possible. This means keeping the witness list confined to actual witnesses of the event or people likely to be able to shed light on the facts. You will only want to interview persons that can contribute something significant to your investigation. Sometimes this means that the only witnesses interviewed are the complainant and the person complained about. Identify evidence. Find out if there's any documentary support for the complaint, or if the employee tape recorded any conversation or has voicemail messages or email messages that support the complaint. If this type of information is identified by the complainant, request copies of the documents, messages, pictures, recordings, etc. Find out the location and the time of any misconduct alleged. If the employee is complaining about someone else's conduct, find out whether the alleged behavior is an isolated incident or has been ongoing. And be sure to ask the complainant what they are asking be done in order to resolve the complaint. At the end of this meeting, be sure to ask the complainant if there's anything else they want you to know or that they want to say about the complaint. Also ask them if they have any questions for you before concluding your meeting. In this interview, you will want to provide assurances to the complainant that you will do your best to keep the complaint confidential to the extent that doing so does not compromise the thoroughness of your investigation. Always remind the complainant that the college prohibits retaliation against them for making the complaint and urge them to report to Human Resources if he or she believes that they are being subjected to retaliation. A retaliation claim is a separate matter that will be handled by HR. It does not become a part of your complaint or grievance investigation. Prepare a plan for your investigation. As a result of this initial meeting, you should have all the basic information you need to conduct your investigation. It is time to plan out your approach, keeping in mind the time limitations set out in the complaint or grievance procedure. Usually, you'll only have 10 working days within which to conduct your investigation and prepare your decision. The investigation plan should include the names and positions of witnesses to be interviewed, identification of pertinent documents that will need to be reviewed, reference to ACC policy or policies that may be implicated, or federal or state law that is alleged to have been violated, and whether or not a conference is needed with HR to discuss any possible legal issues or to answer questions about interpretation of policy. Once you have your plan mapped out, the most important thing to do initially is to line up those witness meetings. You don't want to delay this step because you may find that witnesses are unavailable on short notice. Prepare a list of questions for each witness and identify all topics that need to be covered in the interview. This should be individualized to the particular witness. Witness interviews should be conducted in person if at all possible. A critical aspect of the witness interview is evaluation of the credibility of the witness. This is much more difficult if an interview is conducted by telephone. Resort to a telephonic interview only if there is no other choice. Conduct necessary interviews in a location that is private. Begin the interview by explaining the purpose of the interview, that is, it's an investigation of an employee complaint or grievance, and telling the witness that this is a personnel matter that must be kept confidential. Always stress strict confidentiality. Get assurances from the witness that he or she will not discuss the matter with anyone, including the complainant, unless the complainant initiates the conversation. You can also inform the witness that in the event the complainant initiates the conversation, the witness may, but is not required, to discuss the interview with the complainant. Reassure the witness that he or she will not be retaliated against for cooperating with the investigation. If the witness is in a position to impact the complainant's job in any way, remind them that retaliation is prohibited and that they should not engage in any conduct towards the complainant that would be construed to be retaliatory. You may want to talk to the witness about what retaliation means and warn them not to take their feelings out on the employee in any way. Find out exactly what the witness observed or knows. Get dates of events and names of any other persons who were present or who should know the same information, and identify any relevant physical evidence. Listen and take notes. Do not comment on the information being provided. Do not debate or argue with the witness. Do not contradict the witness. Do not express sympathy, anger, or any other emotion. Ask clarifying questions, but do not indicate in any way that you've reached a decision one way or another as to the truth or accuracy of the facts being provided or as to the outcome of the complaint. You must present a professional and unbiased approach to the interview. This will foster full disclosure and put the witness at ease regarding the fairness of the process. Do not reveal the names of other witnesses who have been identified. For example, if a witness says, "You should talk to Jane Doe," don't volunteer that Jane Doe is already on your list of witnesses or that you have already talked to Jane Doe. Again, as soon as an interview is completed or as shortly thereafter as possible, prepare thorough notes of the interview with the same type of information as was contained in your notes of the formal meeting with the complainant. Gather your physical evidence. These steps do not have to happen sequentially. You can be gathering physical evidence from the very beginning. What do you need to have for review? Any documents, video recordings, tape recordings, voicemail recordings, pictures, email messages, employment records, or college policies relied upon by the complainant or referred to by the complainant in your formal meeting. Any other documents, video recordings, tape recordings, voicemail recordings, email messages, and so forth that have not been relied on by the complainant but what you feel are relevant to the complaint. Your witness statements, your notes of the formal meeting with the complainant, and notes of all witness interviews. Now is time to evaluate the evidence and prepare your decision. Based upon the information provided in the formal meeting with the complainant, any interviews, all relevant physical evidence, and your evaluation of the credibility of the complainant and the witnesses, you must reach a conclusion on the merits of the complaint. You may also want to confer with the Vice President of Human Resources if you have any questions or concerns about the application or interpretation of college policy or about legal requirements that may inform your decision. In making a decision, these are some of the important things to keep in mind. Your decision should be based on established, provable facts. Consider the severity of the complaint and make sure that your investigation reflects the severity of the complaint. Consider what the appropriate outcome should be given the severity of the complaint and the established facts. Consider the need to apply the college's policies consistently and uniformly, and think about any precedent that has been set to guide you in making the decision. ACC policy does not dictate the form of your decision. What is required for a complaint is that you respond in writing to the employee. What is required for a grievance is that you render a decision and submit it first to the Vice President of Human Resources. HR is currently developing a form for use in rendering written decisions on complaints and grievances. Your decision should state the nature of the grievance, list the witnesses that you interviewed, list the physical evidence that you reviewed, list any applicable ACC policies, list any other investigative steps, list the facts that you determined, the conclusions you reached, and provide a recommendation. This does not have to be an all or nothing decision. Sometimes a complaint has merit and something should be corrected even if it's not what the complainant is asking for. As a rule, it is better to keep your decision concise. And remember that only your decision, not any of your notes or other documents or evidence, should be transmitted to the complainant. This concludes the training on complaints and grievances. Thank you.